This is Technically Legal, a podcast about legal technology, innovation in the legal industry, and the impact tech is having on the law. I'm Chad Main, the founder of legal services company Percipient, and on today's show, I'm talking to Jaron Luttich about Element Standard. That's an app he and a co-founder built to help litigators stay organized and increase transparency and provide more insight to clients into their cases. Today, I'm in conversation with Jaron Luttich. He's one of the co-founders of Element Standard. Jaron's story, like so many entrepreneurial stories, begins with a simple observation. Things could be better. He noticed a disconnect, a friction between how lawyers and their clients communicated and how they mutually managed the complex process of litigation. Jaron's a Nebraska native with a law degree from Kansas. He started working at a law firm and ultimately ended up working on the legal services side of things. He worked in legal staffing and e-discovery. Because a good chunk of the projects he worked on related to litigation, he saw the inefficiencies and the lack of transparency and the frustration that often comes hand in hand with complex legal cases. He realized that while technology had transformed so many other industries, the legal world was still largely operating the same way it had forever. Specifically, he compared the way legal was operating to the way the rest of the world operates nowadays, in which transparency is the norm. We track our deliveries, we see our ride shares approach, and we're starting to expect that same level of insight in every aspect of our lives. So Jaron and his co-founder thought, well, what about legal? Like so many other entrepreneurs, Jaron didn't set out to revolutionize an industry. He simply wanted to solve a problem. He saw that litigators were struggling to keep their clients informed, to manage the overwhelming flow of documents, and to train their associates effectively. He saw that clients were frustrated by the lack of visibility in their cases and their feeling that they were being kept in the dark. And so he and his co-founder created Element Standard, a platform designed to bring clarity to the chaos of litigation. They built a system that maps the litigation process, that provides a clear and transparent view of every stage of the case, that empowers litigators to collaborate more effectively and to build stronger relationships with their clients. I see you went to Kansas Law in Nebraska undergrad, so I assume you grew up somewhere in that area.
Yeah, good guess. Not many people come from other places to go to school in the Midwest. But yes, I grew up in Nebraska and did undergrad there and then law school at the University of Kansas. And that's actually where I met my co-founder. We met while we were on law review and we bonded over our mutual disdain for everything we had to do. But it was good bonding and it obviously led to something good 10 years later.
Are you Nebraska football, Kansas basketball, I assume?
Yes. I used to be able to say that was because I could avoid losing, but now it doesn't matter if you're cheering for Nebraska football or Kansas basketball. There's plenty of losing happening.
Yeah. The Nebraska football, I saw that your coach, he doesn't want to play these spring games. Is he sticking to that?
I read that as well, and I guess it's like they don't want to get spied on and then have their people taken out in the portal. They don't want to show off their talent before the first game, so.
Yeah, I don't know if I'm buying that, but hey, it's a legal tech podcast, so this is not Barstool. I'll
Right.
defer that for later. Well, cool. So you go to law school, and I noticed your background. You work at a lot of staffing / e-discovery companies. Epic. You work at Beacon Hill. You work at Hire Counsel.
That's right.
But I think you also practice too, or did I misread that?
Yeah, it was when I was in law school, I clerked for a firm in Kansas City. I took the Missouri bar. They hired me after graduation. I was fully intending to practice litigation with them for a number of years. The long-term goal at that point, I think, was maybe move to Chicago because you could waive into the Illinois bar after a number of years. But even still, I really loved the firm that I work for. I would skip classes my third year to go into work. I just found it so stimulating being able to research and write. And it was, though, after graduation, when I was working there for about 6 months as an associate, when my husband's job had the opportunity to move us to Washington, D.C. For me, it was a big decision to make because, at that time when I graduated, not a lot of us had jobs after graduation. But we dove in, we took the leap, and it was when I was in Washington, D.C. then that I was exposed to something I was completely naive about. And that was what I call the other side of the law, the services side, the technology side. And I started to see that, there was a real quality of life there there was something that was related to the law, but was completely different and very interesting to me. And so I made the leap to give it a try, and I did it for over 10 years. And I learned a lot about legal tech, but I learned a lot about the practice of law, the ups and the downs, the things in our profession that aren't figured out and those that are. But it's a change that I was looking back, I'm very glad I made.
What was your first job there on the services side?
So on the services side, the first job was in legal staffing. At the time, document review was a massive cash cow in Washington,
Especially in
D.C.
DC.
Yeah,
DC was like kind of the epicenter of it for a long time.
that it was. And the office that ended up working with had some heavy hitters in the legal staffing industry. Although I would say every office of every legal staffing company in DC back then had some heavy hitters. They all kind of divvied up all the big firms. There were airline mergers that were coming through, antitrust litigations, and I got my exposure to that. And at some point, I was able to land a big firm of my own. It was really great experience, but it was while getting contract attorneys for that big client. At the end, one of the attorneys from the firm said, "Hey, we actually use this thing, and it saved us over $1 million in document review costs." And I was like, okay, tell me about that. And while they're telling me about it, I'm thinking that was going to be my revenue. So what does the future, hold for me? And it really got me looking a little bit more about what I didn't know. I didn't want to wake up in 10 years and think, where have all my big document reviews gone? And we were already seeing a lot of margin pressure in the industry. And I was like, I need to teach myself more. And so I left a really good company with really respectful management in the private sector. And I went to a publicly traded company, and it was a trial by fire, but I did get out of it what I wanted, and that was understanding the data side, more of what Percipient does, understanding how do you get upstream in that process of litigation.
Yeah, you raise a good point. One of the things we do is manage review among other services, but that's changing. I just saw an article yesterday. I agree with the point. Like, they said, where's document review going to go? The number of people you need to handle a document review is going to diminish. And it's going to diminish sooner rather than later. Do I think it's next year? No, I don't, because the LMs aren't there, but it will, because that technology is going to blow things out of the water. So it's interesting. Like, you started thinking about that years ago, when, it's definitely something on everybody's radar and should be. But what was the last job you held in the services side?
On the services side, the last job I had was with a company out of San Francisco called H5, some of the smartest people I've ever had the privilege of working for. And, we were selling managed services, but with a very strong technology bent to do document review. So that was the last. And in a way, looking back, it was like they weren't a startup at the time, but they still had that mentality, and they still had that kind of drive. And I was a sponge. I mean, I
Yeah,
just everybody there had built that company from nothing, and it was a rather impressive group.
yeah. Were they acquired? I feel like they were acquired.
I believe they were. I can't remember
Oh,
exactly.
Lighthouse. Did a Lighthouse acquire
Lighthouse,
'em?
yeah,
Yeah,
Lighthouse could be.
I think that might be the
Yep.
case. So fast forward to now, or just a few years ago, you become a legal tech entrepreneur
Yeah.
and you create Element Standard. So before I have you tell me what it is, what's in the name? Where does the name come from?
That's a good question. So, it's not one I get very often, but without telling you what it exactly is, within our methodology, within our map of the civil litigation process, we have things that we call elements. And when we were thinking about the name of the company, our first thought was Element Law. And when you look around the legal tech environment and even the non-legal tech environment, lots of things are named Element. Lots of things are named Element Law. I think even in the e-discovery industry, there's a company called that. And so we were like, well, what are we really talking about? And there was something about standardization that we were really focused on at the time. And so we leaned into that, and we've called it Element Standard ever since. And there's been no need to change it yet.
It's a great name. I think it's catchy. It's a great name, and now it makes sense because you've already alluded to what Element Standard does. But as I understand it, it's got two pieces: ControlIt and the litigation cartography. So explain what the app does. It's for litigators to help keep litigators organized and also be transparent with their clients. But what's under the hood? Like, how does it work?
Yeah, so the ControlIt is the name of our software, our SaaS that we're going to market widely with. Litigation cartography is our map of the civil litigation process. So let me back up a little bit. When we graduate from law school, when I graduated, when every law student graduates, we graduate knowing how to find the facts, find the law, make the arguments. That's what we love to do, especially the argument part. And when you look at the technology that litigators love, it's the ones that help them find the facts. And then finding the law. Everyone has their favorite, whether it's Westlaw or Lexis or now the likes of AI tools like Harvey. And then even on the argument side, you're creating the arguments, you're matching the law to the facts, and now you have AI to help you do that. And there are name brands, like I've said, across all of those sort of verticals. But the piece that we're not taught and the piece that we're forced to learn over 10 years of practice is how do you put those arguments into action in your case? What is the actual litigation process? And I'm not talking about task management. I'm not talking about, how do you divvy up the work to prepare for a deposition? No, I'm talking about the deposition, the complaint, the motion to dismiss. These are process points in the process of litigation. And so that is our litigation cartography. And it's what's been lacking because when you are a new associate and you start learning from those around you, you pick up their habits, you pick up what they know. And it's human nature that once you've navigated the complexities of litigation one time, you are bound to repeat that over and over. And you start to lose the forest for the trees. And what we sought out to build was not something that told people how to litigate, but rather reflected how they were already practicing and then also gave them the ability to control that process for themselves by making it completely transparent. So that transparency has applications internally for you, for your team, but it also has applications externally where you can actually deliver a better client experience because you're able to invite them to the table.
When we come back in just a minute, Jaron and I look under the hood of Element Standard. He explains how it can help bring more transparency to client communications and also help train associates and keep them happy. I'm Chad Main, and you're listening to Technically Legal.
We need to do more with less. That is the key takeaway nowadays from almost every survey of in-house counsel. But what if it didn't have to be that way? What if you actually could do more for less? By combining legal expertise and technology, Percipient enables legal teams to get more work done for less. Buried in contracts and sales is frustrated with turnaround time? We can help with that. Did you just get hit with a subpoena and reviewing 100,000 documents and files will tax your resources or cost you a small fortune in billable hours? We can help there too. Our team of legal professionals leverage tech and project management principles with the right amount of human oversight to deliver precise, efficient, and cost-effective legal solutions. Whether it's legal operations and contract management support, subpoena compliance, or document review, Percipient is your partner in really doing more for less. Percipient. Legal services powered by technology.
I get a case in. Let's just say it's commercial litigation. Business A suing business B over something, contract or restrictive covenant or what have you. What's the first thing that a lawyer does if they're using Element Standard to get the project going in the app?
Yeah, so let me describe how we've had to go to market. We work with all the systems your tech stack already uses. So if I'm the litigator and let's say I'm reading the complaint that my client was served. So now I'm having to think about what are our options to respond. So I'm going to go into CONTROLit and I'm going to see that we are in stage one, which is pleadings, and I'm going to see what are my options as a defendant in terms of responding. And now I can start to think about, well, do I want to file a motion to dismiss? Do I need to talk it to my client? So what we do is we actually are a layer that sits on top of your current tech stack, your DMS, your case management system, or whatever, because all of those systems do not have a core of litigation. All of those systems are meant to work with every practice group. And so there's no real match of process to practice in those systems. That's what we provide. That's the transparency that we provide to the litigator into their systems.
So for lack of a better word, it's kind of a UI that connects the dots. So going back to your example where you say, I'm in stage one, I need to figure out if I want to file a motion, dismiss, or answer. It's connected to your document management system, your DMS. So it's getting information. It sees that there's a complaint in there. It sees that, there's some other appearance or whatever. So it's populating, CONTROLit's populating your app, and then the litigator can go in there and see, all right, here's the stage I'm in. Here's what I need to do.
Yep, that's right, because litigation is basically a very simple equation. It's deadlines plus documents equals litigation. And at the end of the day, the only thing that the litigator really cares about are the documents that are in play in their litigation. And the problem right now is our document management systems, our practice management systems, they're akin to like the kitchen. It's where all that work product is made, and it's also where it's stored. And so if you go into the kitchen, you're having to figure out, well, what's actually in play in this litigation? And you're opening up junk drawer after junk drawer. We don't care what your kitchen looks like. We've created the dining room table where you can go and place your work product that you are incredibly proud of, that you've spent a lot of time and effort making, and now it has a place. It's in context with everything that's already been done. So your team can come and say, well, what's happened? I can see it. What's happening now? I can see it. What do we need to do next? Your associates can see the process and be like, oh, these are things we might want to look into. And because it's segregated from your kitchen, where all your private drafts are, where the junk is, you can now invite the client to the table with confidence, because that's the thing that we see over and over and over is
Well, when you say invite the client with confidence, what are you inviting them to see?
you're inviting them to see all the final documents that are in play in the litigation, but they're in context with the litigation process. So this is not just a portal where you're giving them lists of documents. It's actually showing them based on the stages and the parts and the elements that we've outlined for the entire litigation process that this document, this motion to dismiss was filed. We didn't win. Now we're filing an answer. What are our options after that? What can we do? Is there a change of venue, anything of that nature? And the current tech stack doesn't enable the litigator to share things with confidence. So it's why it was an ACC report. Association of Corporate Counsel did a survey, and 93% of in-house legal professionals are not fully satisfied with the transparency given to them into their cases by their outside counsel. And you have to wonder, like, well, why is that? And I don't think it's because litigators have stopped doing things. I don't think it's because they've started being obstinate. Litigators that we speak to, they're like, I want to be transparent. I am transparent. But the practical realities of their practice means they can't be as transparent as their clients are now expecting, because client expectations have changed. And so just giving them occasional updates or giving them a portal where they can see documents without any context as to what's happening, they can't help themselves. And we think there are a couple factors that have really made this a reality, made this reality so negative for the client. And first is just our own experience in society. When we call a rideshare company, we are giving complete transparency into the process so that we can see the car's 10 minutes away, which allows us to get in out of the cold, go get a coffee before that car gets there. And then when the car arrives, we know, well, we can cross the street so that we can get in on the right side. They don't have to make a U-turn. I can get in more safely. We can get on our way faster. That transparency given to us by the rideshare company has allowed us to devote a little bit of our attention and actually greatly improve the service delivery that we've already agreed to pay for. They've done nothing different on their end.
I like that rideshare because I looked at your website. I think it's the litigation cartography, right? If you log in, you can see,
Yes.
to your point, like we lost the motion to dismiss. We filed an answer. Now they serve some interrogatories and the client can see where they are in the case, right?
That's exactly right. And so it's enabling the client to get a very similar sort of experience that they get in their daily life, whether it's from rideshare or Amazon, knowing when your package is going to arrive so you can bring it inside so that it doesn't get ruined by the rain or get stolen. Again, Amazon didn't do anything different. You were given the opportunity to do something to improve that experience, to deepen that loyalty, and then to ultimately give them your next dollar to the exclusion of your competitors. And we think we have that ability for clients because it's going to be on their terms. So I think there's expectations just that we as a culture have changed. So you have those expectations whether you're thinking about them consciously or not. You're like, why is this so difficult? Why there's so much friction dealing with my outside counsel? I don't have this in other places. But I think there's some other things that have changed. General counsel now are investing more in their own talent and their own internal talent. And if they're investing in someone to manage litigation, they are not looking for that person to just monitor spend. They're looking for that person to help make better decisions and to get better outcomes. And so if you're the outside counsel and you're not enabling that, you're not giving them that transparency that allows them to bring their expertise to bear in some way, again, on their terms, then you're actively standing in the way of the decisions made by your client. And you're not going to have that client much longer.
To those ends, you mentioned dollars too, because obviously good service equates to more dollars. But one of the things you tout on the website is that by using the app correctly, is transparency, you're going to boost revenues. How does what your app provides, how does that convert into more dollars for the lawyer?
It's because litigation services are more and more commoditized. As lawyers, you get up to a certain point, you're on the panel for your client, you're one of the outside counsel on the panel firms. What distinguishes you from everyone else on the panel? And this isn't something we came up with. We talked to the head of litigation for a publicly traded bank, and we were showing him, it was actually an MVP of our current solution. And these were his words. He says, when you're on my panel, you're already the most credentialed, you're already the nicest people, and you already make the best legal arguments. There's very little you can do to distinguish yourself. He says, but this allows me to do my job better and faster. And so the firm that brings this to me, that could be a reason to actually give them more work. And I've heard that from multiple in-house counsel at this point. In fact, one of our customers, when we asked him to rank, why are you excited about using CONTROLit? His number one thing was the ability to give my clients more of what they need to do their job. And he is a very driven law firm owner who is, I think he's planning for the future. He's like, I don't like the status quo. What's the future going to be like? How can I get a leg up on all the other counsel that are competing for these cases? And he sees the transparency he delivers to his clients as a real way forward. So that's why we say that, because if you're the managing partner of litigation at, let's say an AmLaw 200 firm, what are the levers you're pulling? I mean, you just go on LinkedIn and all the clients say every client brochure looks the exact same. They all tout the same things. It's like, what can you do? And it comes down to client service. And again, I don't think it's that litigators have stopped doing something they were doing before. I think client expectations have gotten to the point and our current tech stack has not kept up.
That makes sense. And another thing you say too is it protects the value of your associates and helps, I think, also training and stuff too. How so?
So that is really goes back to the origin story of this whole journey. At the end of the day, Element Standard brings transparency to all stakeholders involved in litigation. That is at the top. If you want to define who we are as a company, we're about litigation transparency. Then there are different ways that manifests. There's external transparency, like we're talking about to clients, and then there's internal, to your case team. Because just like the client wants to answer what's happened, what's happening, what needs to happen next, so does your case team. And there's some real productivity and efficiency benefits that can flow to them. But where did this idea even come from? It was my co-founder. He was practicing at a big law firm down in Texas. And it was when he was a mid-level associate, he had a pro bono matter dropped on his desk. And it was a criminal matter. And he had never done anything in criminal law. And so, he taught himself criminal law by basically reading every treatise he could and ordering every book off of Amazon. And after he had done that and handled that case, he was scared. He said, I just taught myself criminal law and I don't even know this much about the civil litigation process. And he was looking towards the fees like, I'm going to be a senior associate. I'm going to be managing people. I'm going to be a junior partner. How can I make sure that I understand what's going on so that I can train the people under me? And so from the beginning, there's always been a strong training bent to our solution. And it's actually one of the struggles that we've had as a company is where do we go to market first? But in terms of the current environment in litigation, there is a lot of fear going forward. Like, what is the law firm structure going to look like? What are the economics of the practice of litigation? There's a lot of fear that, how are these associates going to learn if they're not actually doing a lot of the drafting, but they're just checking what maybe AI has done? And I think one of the ways that you can really protect the value of your associates is accelerating that learning curve from 10 years to maybe a couple months. Because if everything's transparent now, you start to understand, well, I'm reviewing this pleading that was drafted by AI, but I now understand not just the four corners of the document and the claims and the defenses, but I understand in the process of litigation how my partner is utilizing this strategically. I understand why we didn't file a motion to dismiss because our client doesn't think we can ever win them, so they don't want to spend the thousands of dollars for us to draft it. You start to get a connection to what you're doing, and we've seen this play out in real life. My co-founder actually, when he was at a plaintiff's firm, they were interviewing summer associates. And he's like, we actually got someone to join our firm because I showed them litigation cartography. And it was the first time she had seen anything that laid out the process. And she's like, if you guys are using this, I want to work here. And it just shows, like, for me, that catnip of transparency as a baby lawyer, we're seeing that repeated whenever we train new customers on our platform.
Okay, so I'm bigwig lawyer, AmLaw 200 law firm. You come to me and you say, hey, we got this shiny new object, this great app you need to use. Client expectations have changed. They expect more information from you, more consistent cadence. And he's like, "Oh, I've been doing it this way for a while. This is another piece of software that the firm wants me to use. I'm already having to keep organized with the DMS. I'm already having to keep things in our practice management software. Like,
Right.
why do I want to use this? It's just another thing I got to do."
That is a great question. And we have been very diligent at making sure you don't have to do any extra work to use our software. So, like I said before, we're kind of technology agnostic. We're built on Microsoft and M365. So every firm has credentials of that nature. We sit on top of what you're already doing. And we also are non-disruptive to how you already practice law. It was years ago, a very experienced and wise litigator asked me, he was like, litigation is practiced successfully in this country every day. Why do we need you? And I was like, you're right. It is. And litigators know what's going on in their cases, but the problem with practicing law is you have to do the due diligence to validate what you already know before you can take the next step, right? So what really matters are the final documents in your case. That's it. Your deadlines and your final documents. And so by sitting on top of your tech stack, what we're able to do is we take the same action you've always done, and that's routing a document into your DMS for safe storage. And instead of routing it to your DMS, whether that's dragging or dropping or automatically, you put it into ours. And we on the back end, via the magic of APIs, handle all of that process. So you get to the same end result, but with the bonus of having everything in context and complete transparency. So we don't duplicate work, both with deadlines and with documents. The other thing is we're actually not that concerned with how you create your work product. We're not coming in and saying, you have to use this extension in Word. Your Word is now going to be saddled with these other pieces of technology that are going to slow it down, or you're going to have to fill out a whole bunch of information just to open a document for you to do your work. When people complain about legal tech, it's usually because it's interfering with something that's already been working for them. And we've been very focused on making sure we don't do that. And as litigators, I think there's actually a real competitive advantage when a law firm can say, listen, you manage your own practice, but when it comes to the litigation process, deadlines and documents matter. And so you put them into CONTROLit, they filter down into what you're already using, your DMS, your Outlook, whatever it is, but we are not going to manage your tasks for you. You can use whatever task management solution. There are thousands of them that you're already using. Maybe you just use a whiteboard in your office. That's fine. But what matters to the organization is that top level data. The deadlines, are we actually meeting all of them? And the documents, because those final documents then, that becomes the structured data that protects you for the future. Because without that structured data, without understanding how the machinery of your litigation practice works, and not just within one partner, but across all of them, I don't know how you're going to have the data to make the economic decisions you need to make in the next 5 to 10 years. In fact, if I was a junior partner and knew that I was going to be the one forced to make these decisions in the next 5 to 10 years when I was on the management team, the leadership team, I would be just screaming, we have to get structured data around what's happening. And what's unique about Element Standard is it's scalable. We did not go into a single practice and ask, how do you practice law? Let us replicate that digitally. Because if you do that, you put things like medical records in your process because the attorney you're talking to handles a whole bunch of personal injury cases, and medical records is vital to what they do. But it's not actually part of the litigation process. And so that's what makes what we have so unique, is because it's scalable across all practices and it gets you that structured data that then you can actually make decisions with in the future.
You mentioned a second ago you were going back and forth about your go-to-market strategy. What is it now? What's your plan?
So right now, the go-to-market strategy is that improving the client experience through greater transparency. I mean, I don't think you can see those metrics of dissatisfaction from clients and not see an opportunity there. And that's exactly what we see. I mean, the other thing is law firms really struggle to get new clients. It's much easier for them to grow their practice from existing clients. And usually that's like, oh, well, we litigate for them. Let's see if we can get some transactional work, some contracting work. But no, let's try to get more of the litigation. Let's provide superior client experience so that they want to work with us all the time on these matters. That's really where we see our sweet spot right now. And then, there's going to be secondary and tertiary benefits internally because of the transparency we provide and the education opportunities for the associates.
What's on the roadmap? You gonna add features? You focusing on existing feature you want to better? Like, what's the plan?
Well, we're going to the ABA Techshow. We got into Startup Alley at the beginning of April, and we're going to have an announcement there about some new inclusions. But I will go a little bit further out in terms of a roadmap, and I'll take it back to one of the first meetings that we had. So this was, gosh, this is over 5 years ago now. But we wondered, my co-founder and I really wondered, what do we have here? We need some validation. And because of my, over 10 years in selling legal services, I had a pretty good Rolodex. And we went to the head of legal ops for a Fortune 500 company, took him to dinner in New York. We showed him our map of litigation and said, what would you do with this? How would this help you? And his immediate response was, this could save me millions of dollars in legal costs every year. And we said, well, wait a minute, why? And he says, because it's transparent. He's like, the UTBMS codes are absolute crap. They tell me nothing, and what he described was basically a cold war that exists between in-house counsel and outside counsel when it comes to bills.
Which we should say that those codes you just mentioned, UTMBS codes, they're codes lawyers need to use to categorize
That's right.
what they're doing line by line in their bills.
That's right. They're usually accompanied by some sort of narrative. And what was so frustrating to him was that, a month, 2 months, 3 months after the work had been done, sometimes on those bills was the first time he was learning about things that were done. And whether it was per the billing guidelines or not, the amount of money that was spent by both sides just getting the bills correct before they could even be paid. We're not even talking about realization rates. That's another thing. We're just talking about what are you spending on technology to just exchange a simple invoice. And what he saw in our litigation cartography was a means to get real-time visibility and to have every dollar spent actually tied to a piece of work product. Because the codes that are in use right now, first off, they're not litigation specific, and they don't actually tie back to actual work product. And so it's very difficult to value what you're getting. Like, why am I paying $100,000 for this pleading, for this motion? We could use that somewhere else. And you might not have even been in the discussion on whether or not to do it or not. So what we see in the future is that our process map, each point in the process becomes the anchor for every piece of information that is generated by everyone across the entire life cycle of litigation, from we're researching to we're writing to we're filing to we're billing. And that consistency is going to just smooth out that entire relationship and make it almost friction free. And I think it's going to really benefit law firms because so much of their value is lost in the confusion and the chaos. And without context, and that's what we really provide, that transparency and context for the litigation process. Without context, all that collaboration is just chaos. And we eliminate that chaos for everyone involved.
That's good stuff. And congrats about ABA Tech Show. Good luck there. If people want to get a hold of you, learn more about the product, where do you want to send them?
elementstandard.com. You can go there. There's a form you can fill out. You'll get our attention right away. You can contact me at jaron@elementstandard.com. And, following us on LinkedIn, follow Element Standard on LinkedIn. We would absolutely love to have a greater audience there. We are still learning with every conversation that we have. The next few demos that I have in the next week and a half, we have a long list of questions for everybody. And so we're really looking for people that are willing to be honest about what they need and what they need for the next 5-10 years in managing their practices and their firms. And we're very excited. And thank you so much, Chad. This is a
Yeah, of
great
course.
opportunity for us to share our story.
Okay, that's a wrap for today's episode. As always, we really appreciate you listening. If you want to subscribe, you can find us on most major podcast platforms like Apple, Spotify, Google, Stitcher, etc. Also, if you like us enough, I hope you leave us a favorable review. Thanks again for listening. Until next time, this has been Technically Legal.